Today, I am presenting legal aid program across the country. Now, we are talking about the free legal aid. Now, what are the provisions that are provided under the free legal aid? It is representation by any advocate in legal proceedings, payment of process fees, preparation of pleadings, drafting of legal documents, supply of certified copies of judgments, orders, notes. So, expenditure incurring on these activities would be paid. And so, these are the help, or these are the activities which may be extended as help to the weaker section. And free legal services also include aid and advice to the beneficiaries for the schemes that are floated by the central government or the state government, as the case may be, under the welfare scheme program. So, section 2C of this includes any service in the conduct of any case or other legal proceedings before any court or other authority or tribunal, as the case may be. That is to provide advice on any legal advice, on any legal matter. That is to provide legal advice on any legal matter and legal issue to those who cannot afford. And free legal aid is not just confined to the case before the subordinate courts. It is provided at the High Court, provided at the Supreme Court, and legal aid counsel representing such needy persons would be representing before the lower courts, high courts, and also before the Supreme Court of India. So, at all the three levels, they would be providing support and help in providing legal services in the form of counseling them, in the form of legal advice to them, as I already mentioned, that is in the pre-litigation part as well as in the post-litigation part, because most of the cases that might be pending may be settled outside the court, or some of the cases even before reaching the walls of a court could be decided outside the court through negotiation, mediation and conciliation. So, this negotiated agreement is less expensive and it expedites the matter and is also immediate in providing relief to the aggrieved parties, to the needy, to the downtrodden, who cannot afford to fight the expensive cases in the courts of law. And these are the type of cases that may be applied, which I already told you, yes, the pre-litigating one and the post-litigating one. According to section 13, clause 1 of the Act, any individual who satisfies any criteria under section 12 is entitled for the legal services, and the authority is to be satisfied that such a person has a genuine case to prosecute or to defend the matter. Then he will be entertained, he will be provided. Hence, no bar as to which kind of cases one can apply. All kinds of cases included, except for those cases which are not compoundable. The compoundable and non-compoundable offences, we say. So, compoundable are the ones which are compromisable, and non-compoundable are the offences which are not compromised. So, except for non-compromisable or non-compoundable offences, the other cases can be taken up under the legal aid program. Can lawyer of one's choice be allotted to the person who has made a specific choice for a lawyer? Yes, the lawyer as per the choice of the party may be provided. According to the regulation 7(6) of the National Legal Services Authority, Free and Competent Legal Services, Regulations 2010, the application for legal services will be scrutinized, and accordingly the lawyer of his or her choice may be provided. And free legal consultation without pursuing a proper case in the courts. Yes, it is possible to get any kind of legal service under the legal aid services. The consultation without pursuing a proper case also may be provided for those who cannot afford to have the legal representation in the courts of law by incurring heavy expenses. Because most of the people, they spend a lot of money on cases. They mortgage their properties, or in some cases they sell away their properties to fight the cases. And they will get indebted throughout their lifetime. They will be suppressed, oppressed under the loans, borrowed just to fight their case. So this comes as a boon, a blessing for them to fight the cases for the attainment of their rights on equal footing, on equal opportunity, without losing their property, without being indebted to the creditors. So this is where the free legal aid and free legal services will come to the rescue and help of the needy, the indigent. So free legal aid lawyer can be provided at any stage of a case. We can apply to get free legal aid at any stage. At any stage of the case, provided the person who is seeking for this aid should be eligible under the Legal Services Authorities Act. That is, he must be covered under Section 12 of the said Act. So even if we had our personal lawyer before, and now we require, we might have had a lawyer earlier, but now we don't. So we require a lawyer now at the present stage. So can we have the services? Definitely you can have the services under the legal aid program. Now if you happen to see the impact of legal aid, how effective, efficacious legal aid program has been. You can see the facts and figure here. From April 2015 to December 2018, total number of 28.58 lakh eligible persons, including women, children, persons in custody, persons belonging to SC/ST and backward categories, have been benefited through various free legal services authorities. Through state legal service authorities, through district legal service authorities, through taluka legal service authorities, through legal aid clinics at village level, village legal care and support centers. So it's not a small figure, 28.58 lakh eligible persons. But still, comparatively, we have come a long way, and now the help also is to be extended to a higher number than this. And lot many people have to be brought within the fold. And this can be done when they establish law firms, lawyers, advocates, so on and so forth. If they take up the job, the task of helping out the people, helping out the marginalized section of society with their legal services, with their legal help, they can make wonders. They can bring about a revolutionary change. The percentage still is very low when it comes to the extension of help, because most of the beneficiaries would like to have lawyers as effective as who are engaged on remuneration. But if people come out, I mean to say the advocates, the lawyers, the established firms, legal firms, to help out these indigent people as a motto of serving the society, the community at large, to provide them the legal services free of cost. Not totally though. A part, at least 2%, then most of the problem would be resolved. The people would repose faith and confidence in the system. They would feel, yes, we are getting the services as we usually get when we hire a lawyer on remuneration. Now this is the picture that you have of Lokadalats. As I was telling you, the Lokadalat has been given statutory status under the Legal Services Authorities Act. And the types of Lokadalats that are there: separate, permanent and continuous Lokadalats in government departments. They are aimed at amicably settling the pending cases as well as the matters at pre-litigative stage between the government departments and general public. The relationship between the common man and the governmental institutions. So the problem at the end of the common man is to be resolved through this legal service, and to bring about the amicable solution to the dispute, to the rift, to the conflict that may arise. And as I discussed earlier, yes, the entitlement part, the benefits provided by the government to be brought to the reach of this common man. So the departments and general public, so that the inflow of litigation to regular courts is reduced. So because the regular courts are overburdened with a large number of cases pending at various levels, and this has to be eased off. And Lokadalat is a better mechanism, a best alternative method to resolve the disputes through negotiation, through mediation and conciliation. And so these are the objectives of Lokadalats. And under Section 19 of the Legal Services Authorities Act, and also for matters of pre-litigative stage under the guidance of NALSA, the Lokadalats try resolving and settling the cases pending. Chapter 6A has been inserted in the Legal Services Authorities Act 1987. And this was done with a view to provide a compulsory pre-litigative mechanism for conciliation and settlement of disputes relating to public utility services, which supply the basic necessary services such as electricity, water, gas, power and transport, etc. What are the nature of cases to be referred to Lokadalat? And this can be summed up in these three sentences: any case pending before any court, that is any case that is pending before any court, because the two heads which I told you earlier is the pre-litigative and the post-litigating, the pre-litigative and the post-litigative. So any case pending before any court, any dispute which has not been brought pre-litigation, that also can be resolved, that also can be settled through negotiation outside the court. And provided that any matter relating to an offence not compoundable, this is what I told you earlier. The matter which is not compoundable, non-compromisable under the law shall not be settled in Lokadalat. So this is the exception. Rest all other cases can be taken up. And this is the procedure as to how to get the case referred to the Lokadalat for settlement. Now, case pending before the court, the parties, if they agree to settle the dispute, and if one of the parties makes an application to the court, and if the court is satisfied, and that the particular person who has made a request to the court is eligible under the Section 12 of Legal Services Authorities Act, may be allowed actually to be given this free legal service. Any dispute at pre-litigative stage, the State Legal Services Authority or District Legal Services Authority, as the case may be, receipt of an application from any one of the parties to any pre-litigation stage also, they may refer the matter. They may refer the matter to the Lokadalat for amicable solution, amicable settlement. a resolution of the dispute in amicable manner. Now these are the types of regular Lok Adalat: continuous, daily, mobile and mega Lok Adalat. The continuous one for a number of days, specific number of days, to facilitate settlements by deferring unsettled matters to some other date and encouraging the parties to come to the terms of the mutually accepted settlement before the actual settlement. And daily Lok Adalat, of course, is organized on daily basis. The very word mobile Lok Adalat itself is self-explanatory, as taking the Lok Adalat, the entire setup, in a multi-utility van, reaching out to the people, making justice accessible to the common man, to the marginalized section, to the weaker section of society. And mega Lok Adalat, that is organized in the state on a single day in different courts of the state. So this is about the permanent Lok Adalat, which is mentioned under the section 22B of the that is the Legal Services Authorities Act 1987. And the jurisdiction of the permanent Lok Adalat is up to 1 crore. And the award of the permanent Lok Adalat is final and binding upon the parties. Now let us see the efficacy and effectiveness of online Lok Adalats. Honorable Mr. Justice Uday Umesh Lalit, who is the present Executive Chairman, the Chairperson, National Legal Services Authority, he was addressing the audience at Hindustan Times Leadership Summit, which took place on 5th of December 2021. He added that in the physical world, before the advent of coronavirus pandemic, the maximum number of cases that could be disposed of was 14 lakhs by Lok Adalat. But see the big change that has come during the pandemic. The effectiveness of online Lok Adalat, comparatively, in July 2021, 29 lakh cases could be disposed of, more than what was disposed of before pandemic. And then hearing of cases through virtual platform. One more point with regard to disposal of cases before I move on to the next point, that is, in September this year 2021, 42 lakh cases could be disposed of. See, 29 lakh cases in July 2021 and September 2021, 42 lakh cases. So online Lok Adalats have been more efficacious and effective in disposing of the cases. And it helps actually in establishing a platform, virtual platform, paving way for four-way communication between the District Legal Service Authority, those sitting in jails, their relatives and lawyers. Four-way communication. And this could be made possible because of the technology, because of this online Lok Adalats. The pandemic has become a boon in this area. Sorry to say, but the figure shows the huge number that could be settled earlier and post-pandemic. You can see the difference. But again, he goes on saying, Justice Uday Umesh Lalit, sir, he goes on saying that it is our responsibility and no one should be deprived of legal assistance due to financial or any other disability for that matter. And he says, NALSA's motto, Vishwas sabke liye, Nyay sabke liye. And this can be made possible only when all of us make our contribution. And next comes the concept of legal awareness program as a part of the preventive and strategic legal aid. NALSA, through the state legal service authorities, conducts legal literacy programs. The legal awareness camps are spread across, and mostly they help in the rural areas in educating the people about their rights and bringing about the awareness regarding the various programs floated under the welfare schemes by the central and the state government. Now, if you see here, the legal literacy programs are conducted every year in schools and colleges, and also for empowerment of women, besides the rural legal literacy camps. And if you see this figure, that is period of 1/4/2015 to 31/12/2018, 5.35 lakh legal awareness camps were organized. It's a huge number. But effectiveness of legal awareness program can be seen in the latest scenario, as mentioned by Justice Lalit sir, saying that NALSA has undertaken several awareness program campaigns to reach legal rights awareness to the masses, covering 700 million people in 1.9 million villages in the country, as part of a recent 6-week outreach program from October 2nd to November 14th. This is a huge achievement, but still we are lagging behind, we are falling short. That's what he says. He says mere awareness will not guarantee everything. The needs are to be fructified, and confidence must be built. That is the confidence when we provide legal services, the marginalized section, the weaker section should repose trust in the system and the machinery which is providing the legal services to them. On the same footing, when they repose confidence in their own lawyers engaged on remuneration. So similar feeling, similar confidence that they should gain when the legal services authorities provide the legal counsel, the legal service, the legal aid to them. They should not feel that the cases may be botched up. They should not feel that they may be let down in fighting their cases. They should feel that if they were to engage the services of a lawyer on a regular basis, the same services are provided by the legal services authorities. And this confidence can come only if leading senior advocates brought within the fold of legal aid. Once there is confidence, then that flame is taken through the hands of senior counsels, and this will lead to its destination and will show them a greater light. So contribution, let us see. Nyayadeep is the official newsletter of NALSA, promoting a healthy working relationship between the legal services functionaries throughout the country, and is proving immensely useful. And the other one is the most significant contribution by legal services is the justice would be to settle legal disputes through Lokadalats at pre-litigative stage. And if you happen to see the contribution that is made by the legal services authorities, the major contribution that can be witnessed here is the National Legal Service Authority, NALSA versus Union of India, AIR 2014. This was the case filed by the National Legal Service Authorities for recognizing the persons who fall outside the male-female gender binary. The third gender is to be recognized. They must be extended the same opportunities and equality and justice in different fields, as the male and female gender binary does. So this was a landmark decision where the apex court recognized third gender, transgender persons, for the first time and discussed gender identity at length. The court recognized that third gender persons were entitled to fundamental rights under the Constitution and under international law. And it directed state government to develop mechanisms to realize the rights of third gender transgender persons. So these are the major contributions on the part of the legal services authorities, and they have been playing a pivotal role in providing legal services across the length and breadth of the country. So hats off to the legal services authority. So I end my discussion with this, on this particular note, that we would be making more ripples and creating revolutionary changes if people from the different background come forward and contribute their might to the better functioning of this legal services authorities, and in extending support and help to the weaker section and the marginalized section of society. Thank you.